episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation, and welcome to another episode of Surviving the Survivor, the podcast that not only promises to bring you the very best guests in true crime, but we do it day in and day out, and today is no different. We are awaiting one more of the best guests. That would be Brother Counsel, who has his own YouTube channel. He is here, I believe. I'm going to pop him in. There he is. Magically, he has appeared. So I don't need to tell you, but I need to tell everybody that they began deliberating 2 days ago. It was, I've lost track of days, Tuesday afternoon, a full day of deliberations yesterday in the Karen Reed trial. And yet again, another full day. It is 5:02 Eastern time on Thursday. And as one reporter told me inside the courthouse, it is radio silence. No real questions today. Nothing going on. The jury doing what juries do. They are deliberating behind closed doors. Christina Rex is a friend of the show. She's a best guest. She's in that courthouse. And according to her, it has been 14 and a half hours of deliberations. We're going to get into what is going on behind those closed doors in just a moment. But first, the best guests here in the flesh, our mainstay, the man we always can count on, famed Tallahasse Defense Attorney R. Timothy Jansen. Someone on the book tour said, I thought you were always saying, oh, you are Timothy Jansen, our Timothy Jansen. But in fact, his first letter is an R, but it works out so well because he's also our O-U-R. I have a Jersey accent. I had a news director named Diane Doctor, and I would say the word O-U-R like the letter R, and she used to scream at me and say to visualize the word hour as in 1 hour. So I always have to do that when I'm saying the word hour. So there you go. Tim works at the law firm that bears his name, Jansen Davis. He also spent, where's Brother Counsel? He's coming back. He also spent 5 years as a federal prosecutor. He knows the proverbial both sides of the aisle. Martin Radner will be here shortly. He's an attorney licensed in Michigan and New Jersey. His practice is focused on personal injury, civil rights, and criminal defense. He's handled and tried cases in both the state and federal court systems, and he is well known and respected by the legal community, especially where he lives in the Detroit metro area, and he's got his own YouTube channel, Brother Counsel. And then, last but certainly not least, Alita Mazeka, Esquire. That means she's a lawyer. She's a graduate of the University of Texas School of Law, one of the best in the country, and undergrad from the University of California, San Diego. And she started her own channel called Legal Bites, B-Y-T-E-S, which breaks down legal issues in a simplified, digestible manner, which is what we need during these crazy times. So we get back to what's going on there in Dedham, Massachusetts, at the Norfolk County courthouse. 14 and a half hours of deliberations. Tim Jansen, what is the longest you've gone with one of your criminal trials? How long is the longest that you've had to wait? And you have to go back in that memory bank.
God, that's a great question. How long? I had a federal trial, 8.5 hours. That was supposed to be a slam dunk. I think a day and a half, maybe.
So that's not very long with a man with your history.
Murder trials are always longer. They really are. Especially state murder trials.
Yeah. Anytime there's a death, I think jurors really want to make sure that they get it right. So
right.
They tend to go a bit more slowly. And I think also anytime there's a death and they know that there's kind of a circus around the community because of the case, because of the trial. I think that's another factor that sometimes should be considered when we're looking at how long the deliberations last.
Yeah, very good point. By the way, as we all know, there's not a whole lot going on today other than deliberating. I've got some insider information from the courthouse I'm going to share in a moment, but this is a great day. You've got three amazing legal minds. Put those triple Qs in there. I'll go to the bottom of the chat in a moment. and I will take your questions and toss them to our legal experts. If you despise the show, please subscribe. If you love the show, please subscribe. If you're on the fence about the show, please subscribe. And if you're no longer alive, please subscribe.
Well, that's actually interesting, Joel, because I've got my own little story about that.
Please share, Martin.
Yeah, well, as you know, I'm sure I'm not the only one who's been covering this case, but I've been covering it literally.
Martin, no offense. I wish you were the only one, but go ahead.
Well, thank you. But of course, Legal Bites can also cover it. So
I appreciate that.
Yeah, just us two, though. But yeah, I mean, this whole entire case and trial, as you know, Joel, I've come on here before discussing the Karen Reed trial. I think I was on here with Tim actually before.
You were,
yeah, and I've really went into this entire case with as an open mind as possible, being as objective as possible. And a lot of people really wanted to jump on one side very early on, whether you're on the free Karen Reed side, whether you're on the other side. And I really wanted to see all the evidence come out in court. That's how I feel is the honest approach as an attorney, as a trial lawyer, certainly. No matter what you see in briefings and attached to motions, until it's under the scrutiny of cross-examination, I don't buy just everything that's attached to a motion. So I really wanted to go into this trial completely open-minded, and I felt like I did. And I gave everyone the benefit of the doubt. And then after all the evidence was in, and now I can actually think about this case and how I would approach it and what my opinions on this case was. This is my last two videos when I broke down the closing arguments. And right before then, I said, looking at all the evidence, I'm just going to give you my opinion. I just feel that there's reasonable doubt here. If that's the legal standard here, with forgetting about, is she innocent? Is she not innocent? How did he die? How didn't he die? If the standard is beyond a reasonable doubt, was that achieved by the prosecution? And I would just say, after seeing everything, after all the evidence, I can come out and say, I don't believe as an attorney, as a trial lawyer, that they've proven their case beyond a reasonable doubt. You got those two experts, biomechanical experts, who have said very clearly that it was scientifically, mathematically, physically impossible that that's what happened in this case. If that's not reasonable doubt, please tell me what is. And aside from that, you also had some of the doctors, some of these medical examiners and the ER physician, Dr. Russell. If that doesn't get you to reasonable doubt, I'm nervous. I'm nervous. So, and I came out, and I just wanted to tell you, Joel, and people were at me. Like, the other side really unsubbed to my channel. All of a sudden, brother counsel's become biased. He's not objective anymore because, but that's what this case does to you, I guess,
Yeah. Martin, I hate to, as my wife says, story top you, but since last night's show, I've had people tell me the following: jump off your ledge. Your mother doesn't love you. You're a grifter, and everyone's, he's whining. No, I'm not. I'm telling all you lunatics out there to settle down and have some decency and common sense. I wasn't going to go on this tirade, but I just might, and I might come back to it. Just settle down and let's wait for the deliberations here to play out. But that certain faction of people, it's just it's really a sad statement on society and culture that we've gotten there. In my own defense, I had to respond to some of these people on Twitter, so I'm just as guilty as them of some of these things. Although I would never stoop quite that low, but I was having some fun chirping back at some of these clowns. Anyway, I'll get off of that topic. Tim Jansen, I think one of the big issues here that they're struggling with in a big way is these eyewitness accounts, multiple, and how Adam Lally started his closings with I hit her, I hit her, I hit her. I think they're trying to square that. You just heard Martin Radner say, about the legal experts, the reconstruction experts, essentially saying there's no way this was from a car accident. And not only that, the Commonwealth medical examiner implied the same thing, but couldn't go that far. She just kind of had to leave it undetermined. But you were looking up specifics of the I hit him, and what do you have to reveal to us, Tim Jones?
So I saw that in the closing, and I know people keep saying she confessed. And I gave you an example the other night of my cousin Vinny, where the guy goes, "You shot the sheriff." And he goes, I shot the sheriff. And then they call it a confession. With the police report, not what these witnesses said, the police report, in the report on 130, I hope I didn't hit him. On 2-1, could I have hit him? On 2-2, could I have hit him? Did I hit him? Question mark. On 4-6, could I have hit him? Oh my God, did I hit him? That is not a confession. That sounds like someone who was drunk and had a blackout and was trying to reconvene what happened in her mind the night before. She's told by people what happened. She sees him laying in the ground and led to believe that maybe she did. That's not a confession. And if that's the best that the state has, I see why they kept saying, I did it, I did it. That's not what the police reports show. And you can't trust these witnesses who've deleted documents, deleted evidence, did very questionable things. Jennifer, I don't think she's credible. I don't think she's credible. And I think scientists have showed you got an ME who can't tell you the cause of death, and the injuries, you got FBI people who are objective looking at those injuries. That is not from a car crash, from getting hit from a 24-mile-an-hour crash. It's just not.
Lita, you'd like to add to what Tim is saying here about I hit him?
No, for sure. I mean, if you were to conclude that it was an actual confession, first off, you have to first decide that she actually, in fact, said it. And second, you have to then decide not only did she say it, but that is a reasonable, it's a sign of like what her actual mental state was. And I don't even necessarily think that that's like a drunk thing. I think that she was completely wound up from the argument that had started the day before between her. Like this was something that when I was watching the evidence come out from the prosecution, about the text messages between her and John O'Keefe from the 28th, and then the voicemails. And then we hear on closing that it was 53 phone calls after she dropped him off. When you look at that timeline in that full context between them arguing, she's trying to call him 18 times, only 3 of those times does he actually pick up. They are this kind of, okay, I'm not a relationship expert. I'm not a psychologist or anything, but like from what I know about relationships is sometimes you can get caught into a cycle between partners where one of them is trying to get, when they have a certain anxiety or a certain insecurity, they try to get closer to the other one to sort of relieve that anxiety or insecurity. And if you have the other person is trying to avoid the other person, asking for space, you can kind of like end up in this cycle where one of them is trying to get in, the other one's trying to get out. And then it just kind of like feeds itself over and over again. That's what I saw between them on the 28th. And so then on the 29th, when she's calling him and texting him and, leaving so many voicemails for him and all of this kind of stuff, that she's winding up, like there was this question early on in the trial, like how was it that she was so wound up already at 4 a.m. or 5 a.m. when it doesn't seem reasonable to expect him to come home at that hour, even if he was expected to come home, there was a snowstorm, all this kind of stuff. But once you see it in that full context, it makes me wonder, like where truly was her brain at that moment? And then you hear that the actual butt dial, her voicemail to him, it's like 6:08 a.m. or something, where you can hear her in the background saying, Jen, Carrie. None of that seems to relate to someone who is like in touch with the reality of the situation. Like it seems like she's in a complete mental breakdown. Nothing that she's saying is making any sense. So that makes me doubt even if she did say it, it makes me wonder whether or not she even realized she said it or that it was even connected to any sort of like real thought in her brain. So that on top of the other issues of, the only way that we have anyone saying that she said, I hit him, is witness testimony. You have to also address the credibility of those witnesses who say that she said that. And the issue for Jen McCabe, well, there's a number of issues for Jen McCabe, but one of the big ones as to that particular statement is the timing of the first time that she said that Karen Reed said, I hit him. And it was after the Google search thing came out and became public. That for me was a big, big deal when that came out on her cross-examination.
Yeah, by the way, these are all amazing points, and we're going to bring in a psychologist tomorrow. Also, Tomorrow, you're getting literally the preeminent jury consultant in America, Richard Gabriel. He did OJ among a bazillion other huge high-profile cases. I think Phil Spector and others. He's based in Los Angeles. He's going to be here. We're going to do a special show. Of course, if the verdict comes to you earlier tomorrow, we will have that for you live on STS. But in for another amazing best guest panel, thanks to Steve Cohen, who is hopefully flying safely back home. But I think this is a really important point, Martin, and I want to get to this question, but I also want to get back to this, which is Adam Lally put in Karen Reed in her own, she didn't testify, but in her own words, those voicemails, any which way you slice it from a human perspective, are disturbing. She was obviously not in her right mind. Do you think that's part, as Alito was just saying, part of the factor that's holding up these jurors?
I mean, there's a number of things like we spoke about. If you don't mind, I just want to chime in a little bit on what we were discussing just a moment ago. I hit him, and this is kind of what I spoke about on my channel. But when I was going through this, and this is just what I do because I put myself in the prosecutor's shoes and I put myself in the defense's shoes. As the prosecutor, you're obviously going to make that argument, and when you're the defense and you're going first, so you've got to anticipate. You don't always go first, by the way, as a defense. So that way you don't have to anticipate. You just listen to the prosecutor. You can make some notes in case you forgot something. But in this case, when you know you're going first, you've got to anticipate what the prosecutor is going to argue. And to think that prosecution's not going to use this, I mean, this is like the first thing. This is one of their strongest arguments. She actually confessed. So I thought it was a mistake, and I mentioned this. I thought it was a mistake from Alan Jackson not to address it. You've got to address that the strongest part of their argument and try to figure out a way to dispel it, diffuse it. And one of the parts was like what was like Alit was saying. Was it a liter or a light? I'm sorry.
It's a liter, like a liter of milk, she taught me.
Okay. So one of the parts was like, well, Lena, I think that with the way that I would have approached this, and I spoke about this on my channel, because it's not just Jennifer McCabe, so you can't just attack, well, who said it? Jennifer McCabe. Okay, she just made it up and she has no credibility. But there's also other paramedics who have really no connection with the McCabes. Yeah, maybe a distant connection to a Proctor or whatever, but it wasn't just Jennifer McCabe, and that's what Lally pointed out. It wasn't just her. There was 4 independent recollections, paramedics that really have no serious ties to the Albert or McCabe family. So to just attack the credibility of the witnesses, I'm not sure if that would have, I don't know if I would have gone that route, but I certainly would have gone the route of 2 ways. Number one, the way that Alight was saying is that it wasn't after a moment of reflection. Like when you think of confession, the person slept on it, they came and they came to their senses and they just felt bad. They're going to come clean, right? Here, everyone, according to all accounts, she was completely hysterical, beside herself. She was asking 100 times, did I kill him? Did I hit him? Could I have hit him? Maybe I hit him. Is it possible I hit him? And she was asking 100 times. And you can really think someone in that state could already convince themselves that must have been what happened. And therefore, I did hit him. And therefore, when someone's asking, you end up deciding that that's what happened. And therefore, it wasn't an honest confession. And that's like one kind of what Alito was saying. But the other part I think about this is also the fact that, to me, what really did it for the defense, and really why I believe the jury should come back either with an acquittal or at least a hung jury, is the fact of these, you got to go back to the experts. The experts here said that it's impossible physically, scientifically, mathematically, it's impossible that he was hit by the car. And therefore, it doesn't matter what she says. She can think that she got into that car and hit him at 100 miles per hour. It doesn't matter because the science doesn't back that up. And we live in a world where you have to trust the science. Otherwise, gravity's not going to start working. And, so as much as whether you want to believe that Karen Reed actually believed herself, maybe she actually did believe that she hit him, it doesn't matter because it's impossible scientifically that she did. And therefore, it doesn't matter what Lally wants to call it. It just simply didn't happen.
You're hearing, brother counsel telling you very explicitly, if I understand this, brother counsel, very explicitly, you are saying it has got to be reasonable doubt because the 2 reconstruction experts who were independently hired, by the way, and who Alan Jackson nor David Unetti spoke to ahead of time, said it was physically and scientifically impossible for her to have hit John O'Keefe in a car. And you're saying that's a game over moment. Is that correct?
For me, again, I'm not a juror, but if I'd be sitting for me as a lawyer, and I deal with experts all the time, and I see experts in trial, and believe me, I've dealt with experts who aren't completely being forthcoming and are being hired, and they're hired guns, and they're saying what one side wants them to say. I've dealt with many of these experts, and that's not what these two experts looked like. Okay, these were completely independent. Their credentials speak. They're hired by the Department of Defense for crime. These are the guys that are designing the Jeeps that are going into Iraq. These are the guys that are hired by the NHL. These aren't guys that are hired by some insurance company because they want to deny a claim. I mean, they are too, but you're dealing with a completely different level of expert here. They're completely independent. They weren't hired, which is always a strong point that you always to attack the credibility of the expert by saying, well, let's see how much you're getting paid on this case by that side. Oh, and that's not going to affect your judgment in this case. And they showed very clearly how it's just simply impossible. So for me, as a lawyer watching this, that itself is absolutely reasonable doubt. There's no question in my mind. You think about if you're talking about a different standard, preponderance of the evidence, or, a different type of standard, but reasonable doubt, you're telling me that those two experts don't give you reasonable doubt? And then if you want to pile on top of that, Dr. Marie Russell and the medical examiner who said that these, and remember what Lally's response was to this? What was Lally's, what was his great moment that how is he going to deal with this? First of all, just watching him cross-examine it was a cringeworthy, because I knew he wasn't going to be able to knock holes in them. He tried, but it didn't work. And, the less said there probably would have been the better. But his suggestion was, well, maybe you put your arm like this. Maybe if you put his arm like this, that would explain everything.
A brand new theory that no one said.
No one said. It wasn't tested. And if you think for a second, if I'm on that jury, you think for a second that these biomechanical engineers that are testing every single possible way scientifically, physically for this to happen, and they didn't think, oh, maybe he lifted his arm. I mean, it's ridiculous. So Lally had to argue something. So that's what he did. But really, for me, yes, the experts absolutely achieved or should achieve reasonable doubt. But I'm sure Tim will tell you also, juries have surprised us all. We've been in cases where there's no way that the jury can come back with a guilty verdict, and they do. Juries can absolutely do anything. But I mean, I've never been so strong on this case before after I heard all the evidence. And to me, if this burden is reasonable, beyond a reasonable doubt, it just hasn't been met.
By the way, we've got a double header today coming up at 7:00. We've got some interesting brand new information on Donna Adelson. That trial is set to start in September. It's our OG case here at Surviving the Survivor. We're doing a full show on that with some former inmates who are always a pleasure when they come on. They have amazing stories. You'll hear from them at 7:00. From Kay Simantel, glad you brought this up. I hear people making fun of KR's health issues. I think it's wrong. Can't we all agree? Dislike her, but I'm sure she hated it. Why be mean? It's an excellent point. Unfortunately, human nature, people are mean. But she should be off limits in terms of her health issues. I agree with you 1000%. Lest you think we are not an international show, Australia is watching. Gil Kennedy, hi, right back to back from Perth, Scotland. And I've got to personally thank all of you haters and trolls out there, because right now, all of you people unsubscribed got the highest live number of any Karen Reed shows that we have done. So the Howard Stern promo is accurate. Those who love Howard Stern, he used to have this promo on the show, listen for approximately 39 minutes a day. Those who hate Howard Stern, listen for 1 hour and 39 minutes a day. So bring on the hate. Everyone's also yelling at me. I got a little secret for you. When you're a content creator, you want clicks. I'm not going to do things just to get clicks, but you want clicks. That's the whole point. It's like when you run CNN.
A hate watch is a watch nonetheless.
Say that again.
A hate watch is a watch nonetheless.
So everyone's like, everyone, I love the line, you're just doing it for clicks. You damn right I am. This is what I'm doing it for, but I'm not being sensationalistic. Clicks is what it's about. When you watch CNN, it's about numbers. That's what this world is about. That is the reality. So thank you, all you haters, the ones that told me to die, the ones that told me my mother doesn't love me. Some people said even worse things about my mother, who's a Holocaust survivor. Shame on you, to use Alan Jackson's words. Tim Jansen, there's a question from Charles in Charge.
Okay.
How
What
long
is-
can these deliberations go on? There was no questions today, and Brother Counsel made a point about that, but it doesn't seem like they're overly conflicted, not at this point. But how long can deliberations go on, and is it up to the judge, Charles in charge wants to know, to stop the deliberations?
Well, she's not going to stop the deliberations. There was a lot of evidence to go through. She told them to go through the evidence, and they've only been in 2.5 days, maybe. Clearly, they can go next week. I would think by next Wednesday, she might get a feel from the jury, or the jury might send her a message that we might be deadlocked. Then she'll give what's called the Allen charge. And it's amazing how quickly you get the Allen charge, you'll get a verdict. It basically tells the jury, hey, no one's going to try this case better. No one's going to be able to do it. A lot of money was spent on this. Don't give up, but listen to everybody else and see if you can resolve this. People put a lot of time and effort in this, and we know you'll do the right thing. And you're going to get leaks, and you might hear some rumblings about what the number is, if it's close to, but that's going to come on later. Word spreads in courtrooms. Bailiffs who are standing outside that courtroom hear things. So you're going to start hearing things. I think it's not abnormal. I used to have a juror bailiff, and I knew he stood out in front of the jury room. So I knew when the jury come in, he'd look at me and he'd wink. He's never been wrong yet. When he didn't wink, I knew we were in trouble.
Travis James, I'm from Bite Club. There you go. Legal bites. Does the jury know the ARCA experts are independent? Alita, I think they do know. They don't know who independently hired. They don't know it's the FBI, correct?
Right.
But they know they were not hired and did not speak to defense counsel.
Alan Jackson took absolutely every opportunity possible to point that out on both direct examinations and on closing arguments as well. So if they were paying attention at all to what Jackson was saying, they know that those guys were not hired by the defense.
I just want to point out one more thing about that.
Please.
Is the fact that something also that Alan Jackson said is that ideally, right, and the Commonwealth is not supposed to be looking for convictions. They're not trying to figure out a way to win the case.
Right.
That's not what they're supposed to be doing. And he also made it clear that these experts were available equally to the defense and the prosecution. Now, why? Why in the world would the prosecution not call these 100% independent experts who are on the top of their field to give you guys, the jury, the truth? Why wouldn't they do that? It's such a strong point. Anytime that you can show that the other side is not being transparent, they're not being fair, they're just trying to hide stuff, then, that's a very strong point, I feel, with the jury. And he made that point also. They were equally available to both of us. And we were the ones that had to call him and let you know about their expert testimony in this case. I think that that's very compelling. I think it's a very strong
that's
argument.
because that the Commonwealth already decided what they were going to do. They'd made their mind up. They don't want you to bother them with facts and evidence that's inconsistent.
Yeah, well, that's exactly it. But, it tells the jury they are looking for convictions. They're not here just to
right.
Anja here says, I love Carm. What does she think about? Carm thinks there is too much reasonable doubt and that she should not be convicted of any crime in this case. That is Carm's take on this. And you know how I know that, Brother Counsel? We were listening to you, Brother Counsel, on the way home from Tampa on our 4-hour drive. And you know what Carm said? What a smart, intelligent man, Brother Counsel is.
Well, first of all, I want to say that there's no better way to spend your time, by the way, than to catching up on Brother Counsel.
It was amazing. When you're driving from Tampa to Florida and the only thing you see is sawgrass, like coming out of the Everglades for 4 hours, you will literally listen to anything, but you kept us entertained, brother.
Okay,
did you want to add on to what they were just saying? Did you have, oh, I thought you were jumping in there, brother. I'm sorry.
Yeah, no. I mean,
from Charlie Davies here. Is it strange, Tim Jansen, that it's been so silent? Thought we would have had some leaks by now. What do you say to that, Tim Jansen? I've got some news from an insider in a moment, but what do you say to this, Tim?
That's not unusual. the leaks are going to come by somebody that has close connections in the courthouse. It's not going to be Alan Jackson. Yannetti might have people because he tries cases there. Jackson, unless the sheriffs or deputies took a liking to him and he's got close connections, he might not be hearing anything. And I was just thinking, I made a point. I was cross-examining a witness one time, and the witness goes, "Mr. Jansen, are you trying to put words in my mouth?" I said, "No, something more difficult. Thoughts in your mind." And after that witness was completely in my side after that.
And you were living rent free in your head, as they say. I needed that comment up, COE. This is where we're at. Debate is tonight. I wanted to action for this case. I don't get political on the show, but when people are clamoring to watch President Biden and President Trump scream at each other to get their minds off of this, we're in a whole different.
Watch the soccer game. Watch the U.S. soccer team play Panama.
That might be a better. By the way, I'm watching Your Honor on Netflix. It's a great show. He is Bryan Cranston, who I met at the Democratic National Convention. He FaceTimed my daughter. He was so cool. Is probably one of the best actors of our time right now. Scott 05, I think they've been through the main points, but just probably deadlocked in their minds and opinions, decisions. Alita, what do you think of that? There's no real way to know, but it sure is fun to pontificate and try to pretend that we know what's going on. But what do you think of this comment?
Yeah, so I mean, there's nothing that's been communicated that suggests any form of a deadlock at this point. I mean, one of the things that I keep wanting to remind people is that, this trial lasted 9 weeks and we were all able to talk freely the entire time. They were not allowed to talk about it until Tuesday. So, if I had been, I think about myself, if I had been on the jury, the first thing I would have done is just word vomit all of my thoughts that were kept bottled over the previous 9 weeks, which is absolutely everything. I mean, if you've seen my live streams and my recaps, there's a lot of words in all of those coming from me. So if I had to bottle all of that and let that all out, that would have just taken all of Tuesday afternoon just for that, just to let everything out and then come back the next morning to start fresh, to start going through it, deliberately in the way that you should for jury deliberations. But I mean, the fact that there haven't been any communications really from the jury, other than that one question yesterday about the cert report, that they wanted to see that, other than that, there's really nothing that we can hang our hat on in terms of what the jury is thinking and where they're going. And I think that, to me, if anything, indicates the fact that they are just going about it in a way that is diligent, and they are just working their way forward. Absent of anything else, that's the way that I have to see that they're going about this.
By the way, Becky Ireland, how come you never say love you, Ohio, OHIO? I've got a lot of friends that went to the University of Michigan, so they might be sending me the next tranche of hate tweets. But I will say for you, by the way, one of my favorite all-time UFC fighters, the best UFC heavyweight of all time, Stipe Miocic, is from OHIO. Go Ohio. Dawn Foster, on a serious note here, brother counsel, this is something to worry about. If she is found not guilty, I know you're not in the security business here, Martin, will she be able to live and work in her current community? Could she be in danger from those who believe she's guilty, as well as law enforcement? By the way, I don't want to speak about her illnesses, but I've talked to some physicians, and the illnesses that she has are very, very serious. I mean, they could potentially be life-threatening illnesses. So, you got to hope that she's okay. She's had many surgeries over a short period of time. But Martin, to this, are people going to become targets after this case? I mean, I am worried about civil unrest depending on how this goes. Are you?
I'd be more concerned if she's found guilty. Obviously, I think people are more concerned about the possibility of civil unrest of that case. In that way, if she's not guilty.
Well, let me ask you, if she's found guilty, what do you think happens? Does all hell break loose?
I hope not. I mean, like I said, after I've seen all the evidence, I believe that that's the correct verdict is not guilty. And I don't, a lot of my analysis, I'm not so strong about an opinion one way or the other. And this is after analyzing a number of trials. I've never been so strong about my opinion about something. And to me, it's a no-brainer that this is already, as I've already articulated in this in this live already. So I'm going to control myself, obviously, but I can see potentially where other people feel as strongly, if not more strongly than I do, and I feel like I'm more of an even-keeled, objective person. And I've seen I've seen injustices, as I'm sure the other attorneys on this panel as also. We do see that's part of the line. The right thing doesn't always happen. The just thing doesn't always happen. But in a case like this, where it's very, or at least I feel it's very strongly that she should be acquitted, at least a hung jury, she should be free. That's my opinion is. Then I hope that everyone just controls himself afterwards, and then if there is. But I mean, it's a reasonable concern, I think.
I would go so far as to say I don't think a lot of people have faith in the Canton PD to control the emotions after this, but the state police have got to have a plan in place, particularly, as Brother Counsel just said, if she is found guilty on any of these charges. I think there's going to be a problem outside that courthouse. I urge everyone to act civilly, but I don't know that that's possible.
I certainly hope so.
Yeah. I'm sorry, I didn't mean to cut you off there.
No.
But O'Brusty here. Now, Tim, we were just talking about the defendant, but the jurors. I mean, listen, they walk into that courtroom every day. The last bunch of days, there have been hundreds of protesters, free Karen Reed people in pink shirts. It's been a circus. They've been selling merchandise. They know the pressures on. I mean, these people are not living in the bubble that we think they are living in. Is that correct, Tim, or am I wrong? Are they completely oblivious when they come into the courthouse? What's going on in their minds? You think that they are fearful?
They're probably coming in a back door, but they still see it. It's around the courthouse. They're seeing the reporting, and they're not supposed to be watching it, but they get a sense of it. Sure, jurors, especially in high-profile cases, they can be affected. You can see that when normal jurors are affected when they come back and give a verdict, and they won't look at one side because they know there's always a winner and a loser in a case, right? But they still think they did the right thing. And I haven't heard anything about any jury tampering. But what you said at the beginning, I thought was really interesting. Massachusetts and New York have this weird system where the defense has to go first. So these lawyers should have known. They should have already thought, what is the Commonwealth going to argue? You need to address that. And if he didn't do it, then he made a mistake. It's like in our system. The state goes first, we go, then they do rebuttal. If I don't prepare for, I know what's coming in rebuttal, shame on me, because I know it's coming. And it's just a weird system that they do it. And the way they do it here is like in federal court, the government has the burden. You go first, then the defense counters, and then since you have the burden, you get the last rebuttal. I don't know how that system has evolved and why it evolved that way. It's contrary to federal court and many courts across the country. And you got a lawyer from California. Isn't that where Jackson's from?
Yeah, LA.
Is he familiar with that kind of a process? And did he know that? Or, but he's a good lawyer. He did a really good job. And if we believe in our system, if we believe beyond a reasonable doubt you're innocent, there can be no other verdict in this case. And if she is convicted, an appellate court will probably overturn it for insufficiency of the evidence, conflict in the evidence, because it's clear. It's clear there's a conflict in the evidence. It's not like she testified, and then you lose that because, her credibility alone could be sufficient. She didn't testify. I just think an appellate court will look at this and say there's insufficient evidence. And I see people saying manslaughter, DUI manslaughter. Well, wait a minute. She left the scene. And what evidence do they have that she might not have been drinking when she went home before they tested her? So none of that alcohol should be admissible because she could have got home and drank more alcohol and been drinking so that that blood or breath test is not accurate. So there's so many things missing in this case that a normal case does not have.
If I can just jump in for 1 second, Joel,
Please.
I think that the only charge that they actually would have gotten, I mean, according to the evidence that was presented, at least what I saw, is just plain DUI. Plain DUI, I think they would have gotten, because, you know, there's pretty good experts that she was pretty drunk when she was driving that car. But as soon as you try to connect that car to John O'Keefe hitting him, that's where there's reasonable doubt screaming all over the place.
But even then, with the DUI charge, a DUI charge alone, there's still a question because of the timing between when they say she had her last drink and then when they tested her, right? I mean, so many, you know, just like was just pointed out, so many things could have happened in between. And, you know, back to the whole fact that she was winding up during all of those hours in between. You know, if she's the kind of person that when she gets particularly wound up, when she gets very anxious, she needs a drink, suggested by some of the text messages between her and John O'Keefe, she could have been doing that in those hours in between too, when she was back at One Meadows Avenue. So, you know, we don't have any evidence to say that that's what happened because she didn't testify, but you know, there still is a gap that somebody on the jury could be wondering that nonetheless.
Yeah, I mean, it's true, but just to play devil's advocate here, is that, remember, according to Lally, and again, this is also a little bit disputed, how many drinks she actually was caught on video taking. And if you buy that, you know, every time that she was taking another drink, she was drinking it, and that equals about 9 drinks. Well, a girl that size, it takes 9 drinks at between 10 and 12, you know, 10 p.m. and 12 a.m. There's a very reasonable assumption that she's DUI, you know. So whether she drank after she got home or not, you know, okay, that's a decent point, a mitigating factor, but the fact that,
but something we do every day.
Sorry, I don't want to cut you off.
But if you buy that 9 drinks that she drank right before she got in that car, I mean, she was drunken. She was drinking and driving. So
the other issue with that, though, is that, you know, the only thing that we can really say is that the drinks that had shots in them, like those are the ones that I think, okay, they're likely to have alcohol in them. But the ones where it's just like a tall glass of something, we have no idea what's in them. None of the witnesses that testified about her holding a tall glass of clear liquid testified to smelling it or seeing it or sipping it or anything. It's just, it could have been water, it could have been fizzy water, it could have been soda. You know, we have no idea what was actually in those glasses. They just assumed it was vodka, and you know, the prosecution was okay with that. But you know, you do have a good point that on the video surveillance, the drinks, I would say, the drinks that have, you know, where she has a shot of something, those are most likely to be shots of some kind of alcohol. We don't know what also she had for dinner beforehand. And so there's still a number of factors that that can play into that whole calculation as to how much she had actually had in terms of her alcohol consumption that night.
Gary Herman here with an interesting question. I'll toss it to Tim Jansen. Strange that ARCA experts, these are the federal reconstruction experts, tried to prove cocktail glass broke the tail light, but the tail light was intact at 5 a.m. Thoughts on this, Tim Jansen?
Nothing adds up, you know. I mean, the tail light, and Proctor goes back to the scene, and then they notice after that they find the broken glass on the ground. They didn't find it originally when they were there, the police. The chain of custody, he wasn't sure of the chain of custody. These are elementary things that have to be done on a crime scene. And it all leads you to believe and question, what am I looking at? Is this an illusion? Is this like a magician show? Am I supposed to just watch this hand and not see what the other hand's doing? And that's what it seems like. I go back to the science. Those injuries were not caused by that car. And if the car didn't cause those injuries, she couldn't have hit him with the car and killed him. That you don't need any more than that. Right? You don't need any more than that.
Yeah, by the way, I think Adam Lally used the 3-card Monty reference in his closings, which is
he knew what he was doing, right?
Yeah, which is what
Tim knew what he was
doing. From Mal Green here, and I'll toss this to Alita. There is discussion that Adam Lally was not exactly accurate, at keeping in mind that closings aren't evidence, but How is it in any way okay that Lally lied about facts, quote unquote, in his closing? Like Tim said, the eye hit him. Plus, he said only John O'Keefe DNA on clothing and the glass on bumper match, when not all of that is accurate.
Yeah. Well, I mean, and then there was also when he said absolutely no one, unequivocally, he said absolutely no one testified in this trial saying that he had his arm outstretched. I mean, I literally have I'm finally going to come out with my recap for the closing arguments, but that is going to be I'm going to play the clips one right after another where he says that, and then you show Trooper Paul testifying on cross-examination he had his arm out. I mean, that was very, very either he was lying or he just wasn't paying attention, and either way, it's inexcusable. So
Alita, when can we watch that and where? Tell us.
Well, it's going to be on my channel. It should be. I'm messaging back and forth with the editor about it, but it should be like sometime, I don't know, within an hour or two after we.
Well, you better get to Legal Bites, but after you watch my show and before you watch the debate tonight, you better watch Legal Bites. This is a question that keeps coming up, brother counsel, from Navjot Atwal. Does the panel think Judge Bev has demonstrated bias against the defense in this case, sighing, eye-rolling, upholding objections, and general demeanor to Karen Reed's lawyers? She obviously scolded Karen Reed yesterday for thinking something was funny when the judge obviously did not. What say you, brother counsel?
Okay, so unsurprisingly, I spoke about this on some of my videos. I understand why people feel this way. I think that when you're in front of a lot of judges and you see different temperaments from different judges, I did not see bias. Yes, I saw impatience. And a lot of that, by the way, has to do with the fact that this is a very high profile case. Everything's being scrutinized. There's cameras on, and every 2-minute argument turns into a 25-minute argument for the cameras. So when you're a judge and you're listening to Yannetti go on for 10 minutes about something that could have been handled in 30 seconds in a regular trial, it can start. And I think that she really gave each side, especially in the pre-trial motions, if you were watching that, she really let each one kind of show off for the cameras. And, you know, everybody kind of understands that everyone has to show off a little bit. But at some points, it can really start to get to her, and the whole high profile business of it and just everything going on, the theatrics, and it can really get to her. And that's why I think I didn't see bias. I think I saw a judge that runs her courtroom and not exactly the way that I love it. I don't think she allowed certain questions on cross-examination, which I've seen a lot of other judges will allow. They'll allow a lot more leeway. She was very, very tight with the type and form of question that you're allowed to ask. I don't know if you saw this, Tim, but something like just some basic cross-examination techniques that we all employ in a lot of our trials, which of course you throw some sarcasm in there. She didn't allow any of that. So is that bias? I don't think so. It's just the way that she wants to run this ship. And like I said on my trial, I don't think she's biased. I didn't love the way that she ran the courtroom. I didn't love the way that she ran the trial. I don't like that the objections weren't explained. I don't like that there was no argument at all. And there's not even, they weren't even allowed to say a basis for the objection, just objection. And we're all left to guess with what they mean. Yeah. And then it's sustain, move on, or ask it differently. And hold on a minute, maybe I don't want to ask it differently. Or, by the way, just while I'm on this point, so I don't think she's biased. But there was one point also that I noticed consistently, and I was wondering about the other attorneys here because I didn't get to speak to a lot of other attorneys about this, a few. But something that I noticed in this trial that I felt just consistently happened, and if this was happening in my trial, I would certainly make a point of asking the judge to stop this. And that was that the prosecutor, Adam Lally, when he's not allowed to, would lead a witness. He would lead it, and then there'd be an objection, and then the judge would say, ask it differently, and then he would ask it open-endedly, but the witness already got the answer from him leading it the first time. And this consistently played itself out. And I would say, and I felt like if this was me, I would tell Your Honor, this isn't a mistake anymore. He understands this is direct examination. He's not allowed to lead the witness. Every single time he's leading the witness, then I object, then you sustain it. He has to ask it differently, but the witness already got the cue what to answer. So I kept seeing that, and it was as an attorney sitting there, I felt like I would have been jumping on it and would have been making a little bit more of a deal of it. Maybe Alan Jackson did on the sidebar, but I'm just wondering if that also stuck out to the other attorneys here.
Alita?
Yeah, I think in terms of the kind of egregiousness of some of the questions and things that I saw from Lally, in my opinion, that was something that was, perhaps annoying, but not as egregious as some of the other stuff. So like for me, the thing that stuck out the most was, they tried to make that argument in a sidebar or outside the presence of the jury, at least, to bring in the Google search about, her search for a DUI lawyer, trying to say that was somehow showing her consciousness of guilt, which is just absolutely insane. I feel like every single attorney in the country should be screaming over that one. But, then subsequently with one of the, with Richard Green, that's where it was on his cross-examination, Lally snuck in a couple questions trying to get him to talk about that specific search, even though he wasn't allowed to do so. There were a number of things that suggested to me that Lally was not making mistakes, or like having some sort of a lapse in his memory or something, but he was doing things very intentionally. I mean, to your point about the leading a witness, knowing that he was going to get caught and just, okay, just ask it differently. That was very, very frustrating to watch as well.
Here's a comment that the sheep always throw out. I want to keep this question. The alternates have to sit in court. Tim, we're going to get to that in a minute. But here's Robin M., a member of the sheep herd. Did your guests watch the trial? My 3 guests today have all watched this trial. I don't know what are you watching our show? But they're all attorneys with JDs after their name. They might not be saying what you want to hear, but yeah, they watched the trial. I don't know what trial you're watching, but again, I can't tell you how many of those sheep comments I got yesterday. Please, someone get an original thought in their mind when you're coming after us. Please, just at least be original. That's all I ask, just originality. Tim Jansen, do the alternates have to sit in court? And I'm not a grifter.
No.
That's another word, the grifter. Tim, what goes on with he's whining about us yelling at him. All he's doing is whining on his show about what we are yelling at him about. Carmen's going to scream at me, by the way, after this. Do the alternates have to sit in court all day? Tim, what happens to these alternate jurors? I thought in Florida, for example, at the Charlie Adelson trial, they were just excused. They were gone. And the same thing with the Daybell trial, Chad Daybell, Lori Vallow, they're excused. What happens here?
So what happens normally is the jurors are excused from the courthouse, but they're not excused from the warnings not to look at anything, don't talk to anybody, because they may be called back in as a juror if something happens. You get below 12, then the parties have to agree to go less than 12, which I'm sure the defense would say, no, thank you. But going back to the question about the judge has this high profile case. What does she want to not be? She doesn't want to be Judge Ito, right? No judge wants to become Judge Ito from the OJ case. So she has this high profile lawyer from LA coming in, and she wants to make sure he understands this is my courtroom. Okay. You might be smart, clever, dressed with those $3,000 suits, but this is my courtroom. Some judges don't understand cross-examination. You're given great leeway. And that is clear. You're given great leeway on cross-examination. Some judges don't allow it. I was shocked when I found out that this judge was a former public defender all her career, because she's the one that's probably been getting beat up by judges all the time. And I don't know if it's her chance now. She's the judge, and I'm going to control it. But cross-examination should be given great leeway. And that truth. And the reason is, witness testifies, you cross-examination. And the whole thing is, by cross-examination, the truth will come out. But if you limit the cross-examination, then the truth doesn't always come out.
Linda Mon, I mean, this is a good point here. And I'll throw it to Alita. Judge Canoni does have a connection with the Alberts. I think it was her husband that tried a case related to them. I mean, is that some sort of potential conflict of interest in case there's an appeal here?
I mean, potentially there's always a possibility that judges that have been around for a long time, and particularly when someone involved in a case is police, that they're going to have come into contact with someone along the way. I mean, I've had cases where the judge had some sort of like like their daughter was about to marry some guy that was connected to the other side in some way, that was like he worked for the company or something. That this was back when I was doing employment litigation, and like he worked for the company when, you know, that we were suing for something. I can't remember the exact case, but it's one of those things that judges do have discretion as to whether or not they think that they can be impartial, or, you know, impartial enough. Does it have the appearance of impartiality? I mean, here, the issue is a lot of people do think that there is an appearance of impartiality. And so maybe she should have recused herself in this particular case. But given the connections that these people do have across the local judicial system, perhaps because of their work in the police force, the question also then becomes, I mean, how many judges are there that don't have some sort of a touch point with them at some point? I mean, and does she really think that she can be impartial, unbiased, etc.? So, but I mean, in terms of like, can an argument be made? Sure, absolutely.
By the way, the questions today are incredible, and they keep coming, which is why I haven't gone to the insider info, which is not that shocking. I'll get to it in a second, but look at that Dolphins avatar. Love that coming to you from Miami or from Dan B. Although I'm really a Giants fan because I grew up in Jersey. What is your panel's take that Judge Beverly Cannoni, brother counsel, 1, picked the foreman, and then 2, told them to not take a straw poll when they started? She threw a monkey wrench right from the start. I know you practice in Michigan, not Massachusetts. Is this typical or atypical?
Well, in Massachusetts, the way that the foreman is picked is by the judge. In Michigan, the jury decides for themselves who the foreman is going to be, which is probably a better way to do it. Nothing against all the people making the rules in Massachusetts, but you know, you want the jury to get together and say, okay, you know, they know each other. The judge doesn't know who's going to be someone who can conduct the conversations and the deliberations in an appropriate manner, you know. So sometimes someone may look like he's the perfect man or woman and they're not. So you know, that's how it works in Massachusetts. Doesn't work in Michigan that way. The fact that she told him not to take a straw poll, I didn't hear that. I mean, I didn't listen to all the jury instructions because I had to jump onto another podcast. If she told him that, I don't know if that's a rule or not, but it seems a little bit inappropriate to me. Let the jury deliberate however they want. Mm-hmm. So if they want to take a straw poll in the meeting, and I didn't know this, and that's why I thought that after like 2-3 hours of deliberation the first day, they said they want to go home. And what that told me, I mean, that's what I assumed. And again, everything's guesswork at this point. But what I assumed is that they talked about the case, they took a preliminary poll, and they were split. And therefore they said, you know what, it's been a long day. Let's just come back tomorrow and we'll continue the deliberations. Whereas if they would have taken a straw poll and they would have said, all right, we're all voting guilty, we're all voting not guilty, then it would have been over. So I assumed, and again, I don't know if they listened or you don't, once you're in the deliberation rooms, by the way, you can do whatever you want. You know, like, I mean, really, I mean, there's jury instructions. You're supposed to follow them, but, you know, you're supposed to follow the law, but really juries can do whatever they want and they don't have to listen to the judge, and anything that goes on in the deliberations rooms really are not open for any sort of motions afterwards. I mean, you know, there's, and by the way, you know, we've had in some of these other high profile cases where some of the jurors are not listening and watching shows like this. And then that comes out later. So hopefully that's not happening in this case either.
Yeah, that was a murder.
So if you're a juror, get off.
Yeah, that's the problem. Angel Schultz here. Back to Alita, because I have a question for Tim. He's getting too much love. I need to knock him down a little bit.
Please do.
Do you think Karen should have testified, Alita?
No, it's so risky for any criminal defendant to testify in any kind of a case. And I think that where she was winning, I personally think that the defense was already ahead even before they got to their case in chief. I mean, we've been talking a lot about the experts and whatnot, but even when looking at the fact that the Commonwealth has the burden of proof here, and they put on the likes of Trooper Paul, who didn't use math or physics in his accident reconstruction analysis, and then you've got the medical examiners, who both of whom were inconclusive. I mean, beyond a certain point, like they basically were like, yeah, he died of blunt force trauma and hypothermia, but like, We can't say how that happened. And also, manner of death, I don't know. No idea. After 90 days of testing, I could not make a determination. Meanwhile, Trooper Proctor could apparently make a conclusion in 16 hours. But, so like by the end of the prosecution's case in chief, I thought that the defense was already ahead. And I really, truly think that all of the experts that they decided to bring on during the defense case in chief afterwards really nailed it in for them. And I don't think that there would have been anything gained from Karen testifying. There only would have been risk for her to backtrack on all of the progress that they had made.
You know what? Instead of throwing Tim under the bus, well, actually, Tim, let me throw you under the bus.
Go ahead.
I mean, so Adam Lally, he's a one-man show here.
Yep.
He tried this case for 9 weeks.
Three-card Lally.
Yeah, and he's getting beat up left and right by everyone. I happen to think his closing was decent. Do you at least give him credit for seeing this through? I mean, he was basically thrown into the lion's den, and right now, maybe he was effective because there hasn't been a verdict reached. What do you think of Lally's performance?
I
warn you, be careful about saying anything positive because wait, you don't have a Twitter account. You're okay. Go ahead.
No, I question his judgment in taking the case. I question his judgment in the witnesses that he called. I think he should have known what was coming. The defense was able to cross-examine the experts they had. He probably should have done a little more analysis on whether and the charges, how he charged this thing. Do you give people credit for just trying a case? Okay, he tried the case by himself. Did he do it effectively? No. Did he sell the case? And I always say, if it takes you 8 weeks to try a murder case, you don't have a very strong case. Most people can try a murder case in 3 days, and it's all iron shut. You got a death, you bring the ME, you got a couple witnesses, done. He didn't have any of that.
What's a real list? I mean, 3 days seems really. I always thought that
a week long
Really?
murder trial. I got a murder trial getting ready to try in August, and it's going to be a week long. And I've got a bunch of experts. He's got a bunch of experts. That's about normal, okay? But 9 weeks, it's ridiculous.
Tim, you can tell us. Did your client do it, Tim?
My client.
Let me tell you something, Joel.
It's a self-defense case, so I can tell you, yes, he shot the guy.
Stand your ground. Welcome to Florida, everybody. Welcome to Florida.
Otherwise, Joel, I would have told you what the answer to that is without Tim having to answer. The answer is that he didn't ask him whether he did it or not.
There you go. That is, I knew that would be the answer. By the way, I didn't bring this up at all, but Gloria Rivera did. If you are feeling down and out and downtrodden because of all the Karen Reed coverage and all the stress from it, order my book, Survive to Survive. He's peddling his book. Yeah, I am. It's my show. But the reason I'm doing it, it is the most important story that I have ever reported on. It's my mom's Holocaust story, her child survival story, but it's so much more. She talks about life. She talks about marriage. She talks about losing her husband, my dad, her husband to 63 years. And it's really, I think, heartwarming. And Carm offers really shrewd, sage advice. And the book could change your life. So check it out. There I go. I'm peddling my mother, everyone. Yeah, go ahead.
Joe, can I throw myself under the bus now also?
Yeah, please. Please.
Well, I feel like Tim shouldn't be there by himself,
Thank you, brother.
But, talk about Lally and something that I also mentioned, anyone who's going to go up against an attorney like Alan Jackson, to be able to hold your own somewhat, to be in the same courtroom, to be able to argue the motions, to be able to try to counteract some of the arguments and it takes a skill. It does take skill. It takes knowledge. And he was able to at least be there to compete with him, so I know people don't like his approach and they don't like his style and he think he's boring. And yeah, I get that. But, in the law, he was solid. He was able to argue his motions. He was able to argue his points. And, quite frankly, I don't know how it all works in Massachusetts. I don't know if Lally was able to choose whether to take this case or not. And what I imagine is that Massachusetts, when the Commonwealth was getting ready to get this case, and they knew what was coming down, they knew Alan Jackson and Yannetti and these high-profile attorneys going to come in and start boxing with them. They knew they had to appoint someone who was going to be able to hold their own against them. So I imagine that Lally wasn't just a random choice. I assume that he was, chosen to go up against them, and therefore that definitely says something about him. It's an 8-week trial. It's such a grind. A week trial is a grind. I mean, I can't imagine doing it for 8 weeks. It's just, you're not sleeping, you're getting up early, you're not eating. I don't know how these people do it for 8 weeks, but it's, for anyone to be able to go through that, it really says something about them and says something about their grit and character. So, whether it was a good case, again, like we all spoke about, we didn't like a lot of things, but he did it. He stuck in there and he did it. If you're the guy that gets punched out by Mike Tyson, well, you got in the ring with him.
Yeah. Alita, here's a 2-pronged question from Darren Taylor. Mike Tyson says, everything changes once you get punched in the face, especially by him. If Karen Reed is found guilty, will she be taken into custody? She'll be remanded, I assume, Alita, right then, there and then, and held before the appeal process for sure. She'll be remanded. Yeah. There was another question, though, saying, what, if anything, could the feds do if she is found guilty? They are running a parallel investigation right now. Let's say, just for the sake of argument, Alita, that the feds found information out that I guess would point to her innocence, for lack of a better way of saying it. What would happen in that situation?
I mean, if they found information that points to her innocence and that information was also held by the prosecution, then that's a Brady violation, and that's very, very strong argument for her appeal, and basically for a full acquittal. So that would be a very, very big deal. So I mean, the federal investigation could come in to help provide more information to Karen Reed's case, as has already happened in this case. I mean, that's how Dr. Wolf and Dr. Rentschler were brought in the first place, and I think that's how Trooper Proctor's texts came in, right? Like, wasn't that how they got access to those texts?
That's right.
I thought I remembered hearing that. So Karen Reed's defense team would never have gotten those, apparently, had it not been for the FBI investigation. And I mean, imagine if we didn't know about all those texts. Imagine if we did. I mean, I shudder to think about what other text messages there are about other cases that he has sitting in his phone at this point. How many? I mean, and this is why there's already other cases that are being like re-examined that he's been involved in because of all of this coming to light. But yes.
And one of them is the Brian Walsh case, accused of murdering his wife, Anna Walsh. They've already filed motions there because Proctor is also the lead investigator. Wow. Right now, our viewership is at 7777. It's, I guess, better than 6666. But Harry Cruz, love the panel. If the SUV did not hit John O'Keefe, then one must acquit, ? Does the longer the deliberations go, does the defense feel more confident? Tim Jansen, we had Dave Arenberg, the Florida state attorney. Yeah. He said in a typical case, the longer it goes, the more it favors the defense. However, he said in this case, he believes it favors the Commonwealth. Do you agree?
No, David and I disagree on many things. He thought she should have to testify too. No, I think there was a general thinking when you get charged with murder, you probably did it. And the longer it's out, the more reasonable doubt you have. If the Commonwealth had a strong case, the verdict would be guilty by now. So I think the longer it stays out, you got someone holding on because they believe she did it, and the others are showing and telling them, but the evidence doesn't support. But I think she did it. Didn't she confess? Well, look at this. Look at this. Look at this report. Look at this report. And I think they're working their way through it. That's just my opinion.
I mean, if I had to guess, I would guess it's going to be a hung jury because how many times we get a not guilty. So
Martin, if there's a hung jury, will the Commonwealth have to retry this case? Will they retry this case? Silence.
They're gonna wait till they get the jury and see what the vote was, and if it's like 10-2 not guilty, they're probably not. But if it's like 8-4 to convict, they probably would.
I don't know what this comment is here. Proctor's supervisor that would be Buchanan. He rebuked Proctor over the text. Why didn't Jackson ask if that was formally done? Was it documented? And ask about Massachusetts State Police policy and violations committed? Alita.
I don't think he needed to, because just saying that he rebuked Proctor over it just sounds like he just had a conversation with him. So, from if you look at it from the defense perspective, like, it just sounds like he was like, well, you know, I rebuked him, and then he continued on the case. No one ever, like really what should have happened in a situation like that is when you find out about those text messages, he's formally removed from the case, because you have shown that you might have a serious issue as to whether or not you have investigated this case properly. And if his superiors were actually taking that seriously, that's what they would have done. So, but so if you find that was in fact a serious violation of what Trooper Proctor did, like looking at this objectively, if you're one of the onlookers, maybe one of the jurors, then you're going to look at his statement saying, well, I rebuked him, and be like, really? That's all you did? So I don't think he necessarily needed to get more detail on that.
Joel,
By the way, I was planning to go ahead.
If this wasn't a murder trial, Proctor would have been fired immediately. They would have dumped the case if it would just been a hit and run or something. But because it was a murder, they couldn't afford to lose the lead agent on this case. They would have fired him for that conduct in an investigation.
Yeah, that's a good point.
FBI definitely would have.
That's a good point. So I was teasing this in the first minute of the show, and now an hour, 10 minutes in. So a courtroom insider, I was asking about the mood today, specifically about the defense. Because people were saying the defense was starting to look a little concerned yesterday. And the courtroom insider says, and I quote here, definitely a shift. They've stopped taking questions and started walking a different route with police protection. No more scrums with Alan Jackson. Alita, what does that tell you, that he is basically a guy that was up in front of those cameras every single day? Even his client, the defendant, Karen Reed, was in front of the camera, now has taken a step back. Obviously, nerves have to be frayed on both sides here. There's no getting around that. But do you think that Alan Jackson is now seriously worried that this case could be getting away from him?
Well, it could have to do with the verdict, or it could be about something else. We're not privy to any of the communications behind the scenes from all of them, right? And so, we don't know if they have, received death threats or things like that, for example. And maybe there have been some credible ones. So maybe they're thinking, let's take a step back from the public. Let's, keep ourselves safe. Like, that's entirely possible, because this is also happening at the same time that I'm personally noticing a very, very sharp uptick in social media of people on both sides getting very anxious, very passionate, very heated. I apparently this has been a relatively normal thing, but I saw I saw some footage from the most recent Canton Select Board meeting, where there were protesters that came in and were shouting down Chris Albert and saying that he needs to resign and things like that, which was very interesting to me. And again, when I talked about it on Twitter a bit, people were telling me that apparently this happens like every week, but maybe it's gotten bigger, more intense since the trial ended. And so I would imagine that there's probably tensions on both sides. I mean, people are getting much more, I don't know, I don't know if hyperbolic is the right word, but they're definitely getting much more intense in their language, in the way that they talk about this case, that in the hours and the days that are going by with this deliberation. So I would imagine that there is a distinct possibility that something could have happened behind the scenes that makes them a bit more worried for their own personal safety, their own, day-to-day operations as well.
Great point. I agree.
Very, very good point. Well taken. And I think people, again, on both sides are getting very tense, especially if this is a guilty verdict. I think there's going to be some problems around that courthouse. And, certain individuals will be lionized, whose initials might be TB. And he's going to have his following is going to grow. And things are going to get more intense if she is found guilty, because everyone is expecting and anticipating the exact opposite. Martin Radner, brother counsel, one of the interesting points that was brought up is that, Alan Jackson is obviously an amazing criminal defense attorney. We had his former partner, Josh Ritter, on yesterday, but he built this case around a cover-up. The the first 4 words of the opening statements where Karen Reed was framed. And when he gave his closings, it was all about that. Dave Arenberg said that, and I don't know if Tim agrees with this or you agree with this, that he shifted the burden really onto the defense at that point to show that this mass cover-up happened. Was that potentially a fatal flaw by him? Should he have just poked holes, in other words, in the mountains of reasonable doubt instead of going down this other path?
Yeah, I completely agree with that. When you're the defense, you don't want to make your job any harder than it has to be already. And really your job begins and ends by showing that the prosecution hasn't proven their case beyond a reasonable doubt. And therefore, anytime that you're adding anything more that you have to do, and you've got to prove your theory and you got to prove your conspiracy. Yeah. And if it's, and you know, as we're constantly rethinking about this case, if this case comes down to, if your closing argument is just, is there reasonable doubt or not? Look at the experts, case closed, instead of, well, let's think about what Jennifer McCabe texted. Which expert are going to believe about the Google search? Did she do it at 227? Did she not? Did they see the body? Did they not see the body? What did Julie Nagel say? You know, what were those texts? What did they see the dome light on? You know, once you start getting into all of those weeds, then the jury can say, you know what? I don't buy this conspiracy, and therefore I'm going to knee jerk to guilty. So yeah, I think that if they would, you know, hindsight's 2020, if they'd be able to go and think about this case from the beginning and say, what's the best way to defend this case? I think that would have been probably a more strategic to just argue the evidence. You've got those biomechanical engineers, and then that's the end of it, instead of the whole conspiracy theory. But I think they just kind of locked themselves into that theory one way or the other. And then once you're locked in, you can't back out that easily. So, yeah.
By the way, I didn't bring this up. Becky Ireland did. Joel and Carm are amazing. They definitely shine through in their book on Audible. The book, by the way, is titled the same as the podcast, Survive the Survivor. It's my mom's take on life. She's a Holocaust survivor. She lost her husband. She's a licensed therapist. You're going to learn about life from this book. Check it out, please. And back to this. This raised an interesting point, Tim Jansen. Some of the taillight fragments were found before the car got to the Sally port. No movement of John's phone after about 12:30. Experts are sometimes wrong. What this brought to mind here is I'm going to walk myself right into a trap here, my own trap, but I've been following this case very closely, and I got to be honest, I still can't figure out the whole tail light issue. So what makes us believe that the jurors are going to get in that deliberation room and be able to speak to each other and really understand what's going on here? Because, like you said, 9-week trial, so many things brought up. So many different avenues and tributaries that people went down. Is it almost an impossible job for the jurors to, pardon the pun, piece this back together, sort of like a taillight?
Puzzle pieces like the Markell trial. Yeah, it is. It's a lot. And the one thing I do want to say, and I'm going off topic, Alan Jackson is a very talented and a really good lawyer, right? He's trying a case outside of his venue. Massachusetts and this town, they don't like outsiders. Okay. They really don't. You know, they got Yannetti there. Maybe they don't take him as serious as they should. They look at him as this slick, really wealthy lawyer coming in there. Maybe they're not buying him. And maybe when he pushed to go for the conspiracy, instead of sticking to the reasonable doubt, they're giving themselves in their mind a reason not to go with him. I don't know if that's true. I think he was a very talented. I think he's a good lawyer. I think his cross was great. Maybe his delivery was maybe too slick. And maybe he got caught pushing the corruption, which might have been too much for these jurors to buy in that little community. They could probably buy there's reasonable doubt if he'd have focused just on the experts and the medical examiner, and everybody saying it couldn't happen this way, and sat down. But sometimes when you're in the heat of litigation, you guys know, you the adrenaline goes on, and you say and do things, and then you're locked into this thing, and you start thinking you're doing really well. And unless you know what that jury's thinking, you might be pushing their case the wrong direction. And while you did 9 good things, you did 3 bad things. So we'll know. I think we'll know either after the verdict or when the jury comes back or a juror talks about the case. what they liked, what they didn't like, what was holding them up. We may be totally wrong, and it might be one or two jurors that just want to go through all the evidence, and they're piece by piece going through it.
Yeah, and Alita, this is a great question. Does the jury have to actually buy the conspiracy? If you use the word conspiracy, they yell at you to use the word cover up. So does the jury have to buy the cover up theory to find not guilty? No, right?
Okay. No, not at all. I mean, there's you can think of it like the concentric circles of a target, right? So long as you land anywhere on this target, you end with an acquittal. The outermost one, which is, you really have to believe it, is the framing theory, the conspiracy theory, framing theory, whatever you want to call it. Just inside that is, well, the framing theory saying everybody involved in this case from the prosecution side was involved. Then just inside that, you've got, the same framing theory, but maybe it was just, the police force and, the Alberts and the McCabe's. And then you go in, well, maybe it was just involving these people. And then you get to like the last two circles. And one of them is, well, I think that she affirmatively is innocent because, it's impossible for this to have happened because of, the injuries to John O'Keefe just don't match the damage to the SUV. But the very, very center of the target is the fact that the prosecution did not prove their case beyond reasonable doubt. If you think that there's reasonable doubt, you're still on that same target on the same target as everybody else. You're just not in the same spot, but you still end up with an acquittal.
Right. I just add on that. I think that it's so important for the jury to understand, and I guess maybe this is another thing that could have been explained to them, is that they don't have to solve this problem. They don't have to solve this puzzle. They can leave and saying, I have no idea what happened, and that means an acquittal. They don't have to choose a theory. Not knowing is a not guilty. So
that's a great point.
Stress, and that's what they have to understand, that they don't have
Brother Counsel, I know that can you address this? Coolidge, can someone please correct that statement? No pieces were found prior to the car coming back to the Sallyport. Stop letting false information onto your channel. Brother,
from what I recall, the evidence. Yeah, from what I recall, the evidence, the first piece of taillight was found at 5:45 p.m. That car was towed to the Sallyport at 4:17 p.m., which Proctor put on the affidavit that it was towed at 5:30. So, from 4:17 p.m., it would have arrived at the Sallyport before 5:45, and therefore, no, the first piece of plastic, from what I understand the evidence to be, was not found before that car was at the Sallyport, or at least on the way to the Sallyport.
We're going to get to a poll in just a few minutes. We're going to wrap. Fastest 90 minutes of your life. You guys are going to have to sue me to get your time back. Georgia OKC here. Walking you into a huge trap here, brother. It's COUNSEL. Is Brother Counsel on? Are you on Twitter, brother?
Brother Counsel is on Twitter for right now, just simply posting my videos on Twitter, because I'm not sure if I want to get into all these Twitter wars like Joel and some other people get into.
Trust me, you don't. Trust me, you do not.
And I'm trying to, stay disciplined about that. But I figured it would be helpful to have a Twitter, so I have a Twitter. I'm posting my videos there. I'm just not sure what else I'm going to do with it. But officially, I do have a Twitter page with something like, 40, 48 or 50 followers right now. But kind of just to lead you to my YouTube channel.
I'm so jealous. Here's another one that comes up often. Why does everyone think a conspiracy has to be a million people? Every piece of evidence, every interview went through Proctor's. P.S. A conspiracy only has to be 2 or more people. Sometimes you have to use the word cover up. Tim Jansen, there's a tweet going around right now. What about, Karen Reed could have taken a plea deal, 16 months. You would already have served her time, been done with it. What is it about? Defendants who I guess really believe in their innocence do not want to take a plea deal. In your estimation, is it something that she should have thought more about?
Well, Kathleen McBanoa was given full immunity and she didn't take it. And the evidence in that case was much more stronger than it is in this case. She probably saw the evidence, or maybe she just genuinely believes she's innocent and her lawyer believes they're innocent. And they believe there's no way they're going to get a conviction. At the worst, they're going to get a hung jury and they're not going to retry this case. But I don't know. You always do what's in the best interest of your client, because I tell my clients, hey, we go to trial and we lose, I'm going home. So you make the hard decisions, not me. I'll try this case or we'll enter a plea. And usually the defendants themselves are the ones that's supposed to make that decision. They look to you for guidance. Can you win? What do you think will happen? But ultimately, the defendant has to make that choice.
And just to add on to that, something that I always talk to my clients about is that, no matter how strong of a case we have, when you're in front of a jury, the jury can absolutely do anything. And like Tim's note, we see all types of injustice all the time. So no matter how confident you are in your case, just understand when you're playing a little bit of Russian roulette when you're going in front of a jury. On the other hand, a guy or a client who completely is 100% innocent, and we've all had clients like that where it's hard to tell them to plead to something that they know that they're 100% innocent. It feels so unfair. So how do you tell them, well, let's weigh the balance? It's very difficult decision. So I can't blame Karen Reed for not doing it if she believes 100% that she's innocent. On the other hand, I wouldn't have blamed her for taking the deal either, because juries can do absolutely anything. So,
Lucci from South Africa says there's no way the car could have hit John O'Keefe. There it is. They were all in on it, the cover up. Prosecution are proud to now admit the screw up. There's a lot of corruption, obviously, in South Africa. Got a big problem with that in South Africa. McSpunky is here. There was just another question up. Collier Landry in the house. Check out his channel. Kat Randall gifting 5 survivor memberships. Our friends. Well, here's one of the questions. Tim Jansen, can defense rest too early? Was that a problem here?
I don't know what more they would have put on. They brought in these independent experts. They brought in the experts on the phone to give a contrary version of when that 227 Google search took place. That just smells, it just smells. At 227 or 5 or 6, someone wants to know how long it takes to die, and it happens to be Jennifer, happens to be the same one who said, I heard her say she did it. It just doesn't add up to a clear picture of what happened. And so I don't know if sometimes you put too much on and you regret it. And while you're waiting for a verdict, I can tell you, every lawyer will tell you, waiting for a verdict is like waiting for a child to be born. It's the most unproductive moment. You can't do anything. All your mind is thinking, should I have said this? Oh, I shouldn't have said that. And you're waiting and waiting to see if you were right. It's horrible.
Stop. You're making me get all those feelings again.
But you got to keep up a positive with your client. And sometimes the verdict's not, and you got to keep a positive for your client. It's a difficult time.
It sure is. And I'm glad I'm not either Adam Lally or Alan Jackson or David Unetti. Bill Davis, this was a big deal yesterday, Alita. How significant was the defense's argument regarding the verdict form? Did the defense have a valid point that by not including a not guilty box could somehow steer the verdict? As you'll recall, Alan Jackson went toe-to-toe with Judge Beverly Cannoni about this issue yesterday. And at the end of that, Judge Cannoni reprimanded Karen Reed because she started to laugh for some reason. But how big a deal was this?
Well, so to be clear, the verdict slip form that they were talking about that is apparently used in Massachusetts. Judge Cannoni said that this is very common and typical in Massachusetts. David Unetti said, I've never seen this kind. So, that was a very interesting sort of twist there in that particular hearing. But is different than you would see in a lot of other jurisdictions that have lesser included offenses, where you get basically a flow chart where you start with, the main charge, and you say, do you find Karen Reed guilty of, X? Guilty, not guilty. Okay. If you said not guilty, proceed to the next question. And then you start with the first lesser included. And then you say, not guilty. Okay. Next lesser included. And then you go all the way down the line until you've gone all the way down and there's no more options. That's if she's not guilty of everything. But here it was a little bit different because the boxes were, for this particular offense, pick one of the 4, essentially. Not guilty, guilty for this one, guilty for this one, guilty for this one. And I can understand how some people would be confused by it. I personally wasn't confused by it. However, one thing that was pointed out from some other attorneys, which I agree with, is the issue with that particular form that they, I guess, typically use in Massachusetts is if you end up having a hung jury on a lesser included offense, in which case with the typical form that you see elsewhere, you can at least rule out those bigger charges because you've already acquitted the defendant on those charges. So that rules out, the prosecution bringing a whole new trial for those other bigger ones, right? So you would just be able to bring another trial on those lesser included offenses. But this particular form doesn't allow that. Now, the actual, what ended up happening was after that whole, that sort of back and forth between Alan Jackson and Judge Cannone, later on, she came back and said, okay, fine, I'll do what you want, and basically give instructions that kind of gives that same sort of instructions of that flow chart of like, first proceed with this one and then go to the next one, the next one, the next one. But from when I was watching it, it didn't quite fully satisfy everything because of the issue of like, checking a not guilty box for those, those first offenses, to the extent that if they end up on one of those lesser included offenses and they end up hung on one of those, there still isn't an indication on the form as to what they were deciding on those bigger ones. How far did they get along on that form? I don't know if maybe they have some other supplemental form that they can add, that they can include, or that they use in Massachusetts to show that. But that was just one of those things. But Jackson was satisfied with it, and so he was happy with it, and that was it.
There you go. AJ Alioto, the true voice of reason here. It's only been 14 hours.
Agreed.
I guess in the grand scheme of life, it's relatively little. Coffee Cake reminding us that 42 minutes of Sally Port video are missing. So many crazy things in this case, and I think that's why the tempers are flaring on both sides. Here is the STS poll done 14 minutes ago. 2,365 votes. You guys could be the jury. Not guilty, all charges, 72%. Guilty, all charges, 3%. Not guilty on murder 2, but guilty on manslaughter, 10%. Hung jury, 15%. As the wait continues, I just want to thank these best guests, the best of the bunch. Alita Mazeka, Esquire. She's a practicing attorney, a member of the California Bar and DC Bar. She is also the founder, creator of Legal Bites, a great YouTube channel that breaks everything down in condensed form. And she's going to have a new video up from closings sometime in the next hour or two. So check it out. There is a tweet here from the Prosecutors podcast. They won Best Podcast last year at CrimeCon. Friends of ours, Allison Brett. Here's the tweet from them. On the Karen Reed jury, unless you have some zealot who is dug in either way, this jury wants to get a verdict. And if you had a zealot, we'd probably know that by now. They've spent a lot of time on this case, and they don't want it to hang. The lack of jury questions tells me they are still moving productively toward a result, whatever that may be. It will be surprising if we don't hear something from them tomorrow. Alita, your reaction to that tweet?
Yeah, no, I mean, that's like, I said earlier, the fact that they haven't had many questions, they haven't had many communications. It to me personally indicates that they're focused on making their way through these charges and putting the evidence together in order to answer those particular questions. So they don't seem to need so much guidance from the judge, which suggests they're not so confused about things. They know they seem to understand the assignment. Maybe they do, maybe they don't. Maybe they think they do. But it to me, everything to me suggests that this is progressing forward in a way that is productive still. So to me, there's nothing that suggests that we're in hung jury territory anytime soon. I wouldn't even think about it until at least after the weekend. If we got to the end of Monday, maybe I would start thinking maybe they're going to hang. But at this point, tomorrow I could totally see a verdict coming out tomorrow. I could see a verdict coming on Monday morning, first thing, that maybe by the end of Friday, they say, okay, we need the weekend to think about it, feel it, we rest our head on a pillow for a couple days, take a step back away from all of this information, because it's been an overwhelming 9 months, not 9 months, 9 weeks. It feels like 9 months.
Like the OJ trial.
Yeah, exactly. But, you know, and just to say, I need a couple days to make sure that I am absolutely correct about this decision. Whether it is to put Karen Reed away for 15 years to life, or whatever, whichever of these charges they end up, guilty on, or whether they decide to fully acquit her on everything, and look at the O'Keefe family and say, no, we are acquitting this person who is on trial for murdering your son, who, whatever they actually believe about this particular case. So they probably will want to, not probably, there's a good chance that, at least a chance, that they might want a little bit of time just to be absolutely sure in a case like this. Remember, it is a murder case. So there's a lot. And I would imagine that the jurors have all of the awareness of the seriousness and the gravity of that decision.
They should. It is obviously someone's life depends on it. So hopefully they are taking it, which it sounds and seems like from all indications, very seriously. That was the prosecutor's tweet. Bettero Law, who is very pro-defense. He says in a tweet 10 minutes ago, by the way, I really like him. Stop panicking. This is normal. Karen Reed is not going to be convicted. Martin Radner, he's an attorney licensed in Michigan and New Jersey. His practice focuses on personal injury, civil rights, criminal defense. He also has the amazing YouTube channel, Brother Counsel, where he breaks things down. And my mom, Carm, says he's smart, so you got to listen to him. I guess this is a little bit out of left field. Is the inverted Sally Port video considered a Brady violation? Martin Radner, for those who do not know, what is a Brady violation, and your final thoughts here?
Okay, no. So the inverted part, no, I would say is not a Brady violation. The part that some of that video wasn't even available till in the middle of trial, that really has me questioning whether that's a Brady violation. They only had the grainy part, which was missing, the important part. That's what they had before. And then all of a sudden this beautiful clear one they only got in the middle of trial. That might be some arguments for Brady right there. Brady obviously is being able, turning over exculpatory evidence to the other side, which the prosecutor has a duty of doing. Can't hide all the good evidence that's going to help the defense. So yeah, that might be, but I don't think the inverted part is. And like I said, I believe that it should be a not guilty from my experience in the law. I believe that there's reasonable doubt here. My call, though, is that it's a hung jury, because I've met some of these other sides and have been screaming at me and have been unsubbing from my channel because I've, pointing out what the evidence shows. So these people are out there, and there could be one on the jury who's refusing to acknowledge the expert's testimony and refusing to find her not guilty. So my call is a hung jury. And I believe it should be not guilty, but that's my call.
You heard it here from Brother Counsel, aka Martin Radner. Former Tallahassee Defense Attorney R. Timothy Jansen, partner in the firm that bears his name, Jansen Davis, also spending 5 years as a federal prosecutor. Tim Jansen, what's going on? What's going to be the end result?
So, the feds are involved and they're investigating this matter. They hired these experts, and then they find some documents, some Brady material, the texts and tweets between Proctor. So defense wanted to wait till the federal investigation got over. The feds are just sitting there waiting, like we always do. We're waiting because what we do is we get more evidence. And we get more evidence. Now we have witnesses who took the stand and testified under oath. And lo and behold, what if the feds have evidence showing that these witnesses perjured themselves in the trial? And they contact these witnesses and said, we know you perjured yourself because we have these documents to show that you perjured yourself. Now, do you want to come clean? We've got a case going on. You step up to the plate. Tell us what really happened. And could that happen? Yes. Because I think it's enough that the feds are involved. The feds know now, right, from these experts that they hired, that this car did not cause the injuries on that person. So they know there's something sinister going on in this case. The question is now, Do they have something independent away from the Commonwealth that can prove that one of these witnesses may have perjured himself and then pressured that person to spill the beans? Could that be in the future? Hopefully it is. Because if we can find out what really happened, I think all the subscribers, all the hate mail, everybody wants to know. And I tell you what, I think the people who are pushing for guilty, if they find out that in fact they were wrong, I think they'll admit it, because I don't think anybody really wants the wrong person to be convicted.
Amen to that. No one wants someone who is innocent to ever go to prison. Darlene here reminding us what this is all about. Justice for Officer John O'Keefe, an amazing panel tonight. It's not just a tagline. It is our reality. The best guests in true crime: Martin Radner, Alita Mazeka, Tim Jansen. Thank you for being here. Love you, America. Love you, Detroit. Love you somewhere out there for Alita. Not an undisclosed location. Love you, Tallahassee, Florida. And of course, love you, Canton, Mass, dead in Mass, where this trial is going on. Justice for John O'Keefe. I can't believe I'm saying this, but I'm going to see it in. Thank you to Patreon, by the way, the backbone of our podcast, really, truly, especially on days like today when the hate's coming at us collectively, are the mods who. That's why they moderate. That's why their names are the mods. So huge thanks to the mods, Space Coast on the West Coast, who is, you see the mods right there: Frankie Figs, Julie Fruit, Gen X Granny, Copper Horse, Shaquille Oatmeal. Space Coast on the West Coast is my muscle in case things get too ugly. Two baddies on the West Coast, and the COE, of course. And last but not least, Steve Cohen, the brains behind the podcast. We'll see you in 18 minutes. Love you.